Everyone. It is 1:03, so in the interest of time, we're gonna get started here. Oh, I like that faux gavel action. We'll start with introductions, and then Tad Johnson is supposed to be moderating, but he just finished his remarks and I think is grabbing lunch, so he'll be joining us as well. But I will turn it over to Chief Executive Benjamin.
Good afternoon, everyone. I am Melanie Benjamin, and I'm the Chief Executive for the Mille Lacs Band of Ojibwe, and we're about 100 miles north. And I've been in my position as elected official since 2000, so every 4 years I've been honored and very pleased that the people put me back into the position to work on their behalf. And so I'm very pleased to be here and to see all of you, so I say welcome.
Good afternoon, Jesse Stomsky-Syme. I'm General Counsel for the Prairie Island Indian Community. Been in that role for over 7 years, and before that, I represented various tribes in private practice. I'm a citizen of the Muskogee Creek Nation of Oklahoma, and I'm very happy to be here with you all today. I'd like to recognize the tribal leaders in the room and elected officials and everyone else here with us today.
Yeah, Buju Ginawa, my name is Phil Brodeen. I'm from the Boys Fort Band of Lake Superior, Chippewa in the northeast corner of the state. I'm General Legal Counsel for the Minnesota Chippewa tribe. I also do work for a number of other tribal governments here in the state of Minnesota. Very excited to be here. Thank you for having us.
Okay, so I get the opportunity to start a little bit about law enforcement. And so I will begin in the 1950s. And if you were in the session, you would have learned a little bit about that law, which is called Public Law 280. And that transferred federal criminal jurisdiction on most Indian reservations in Minnesota to the state. And fast forward to 1991, the Mille Lacs Band worked on a law, Minnesota Statute 62990, and it was the first law on a public law 280 Minnesota reservation that provided that an Indian tribe could appoint peace officers and exercise law enforcement authority. Under the law, any of the peace officers that were with the Mille Lacs Band had to be post-certified and were paid by the Mille Lacs Band. The band had to waive immunity and agree to be responsible for torts committed by the officers and to purchase insurance for them. All officers would refer suspects accused of violating state law to the county attorney for prosecution. Section 629.90 states that the band shall enter into a cooperative law agreement with the county sheriff. And so for us, that means Mille Lacs County, Pine County, and Aiken County. The first such law agreement was entered in 1991, shortly after the law was passed, with one interruption in 2008, that this agreement has worked well for 25 years. The county and the tribal police, they worked side by side. Although we were in our infancy in 1991, we have evolved with much training and other relationships with other law enforcement trainings, and we have become a very sophisticated, highly trained and well-funded law enforcement agency. Many law enforcement agencies, including city police departments, county sheriffs, and state patrol, and other state law enforcement agencies and federal law enforcement agencies, commonly exercise what they call concurrent jurisdiction. That means both entities can have jurisdiction over an issue. And normally what happens is you don't have to have an agreement, and you don't have to enter into cooperative agreements. And so it's kind of interesting that police departments have to do that, especially from the Mille Lacs Band's perspective. And even though we feel it's not necessary, and we also feel that it's an affront to tribal sovereignty, it is a subject to abuse, and we have experienced this firsthand. With our success of casinos, and which is, of course, a huge economic benefit to the tribes, and provides jobs, opportunity for housing, all the benefits that you get from generating revenue. Well, it also, not only did it bring in customers from around the state of Minnesota, it also brought in gang and drug dealers. And they came right to our reservation. So if you look at the state of Minnesota, the Mille Lacs Band, we're the most southern tribe, Ojibwe tribe, and everything north is the other 6 reservations. So that's kind of from the Minneapolis-St. Paul area. Mille Lacs is kind of the first stop, then it goes further. And then I see we have elected officials out there that were past law enforcement officers, chiefs. So if it looks like I'm saying something wrong, shake your head and I'll divert to another topic. So, so in 2013, for the Mille Lacs Band, we felt because there was this influx of these negative individuals coming to the reservation and also starting to provide lots and lots of drugs to our people, that we needed to do something about that. And then the federal government had a law that's called the Tribal Law and Order Act. And so what that does is it assumes jurisdiction. And for the state of Minnesota, we're a public law 280. So we do have concurrent jurisdictions with the state of Minnesota. So we said we want more than that. And so we applied to have a status as tribal law and order tribe. So the resumption of federal jurisdiction, and it wouldn't limit the state jurisdiction, but it would just enhance it. And there would be another level to address these issues under the federal jurisdiction. And of course, our county and Mille Lacs did not want that. And they were certain that if we were granted that authority, that would lessen their authority. And we wanted to take jurisdiction away from them, and we did not. And we just wanted to make sure that we had another law enforcement tool to send to the drug dealers and gang members and any other people that were violating law, that we have another option for you. And we want to make sure that if you come on our reservation, we don't want you to commit any crimes. And if you do, you will have the possibility of going to federal court and going to the federal prison. So we submitted our application to the Department of Justice. The county opposed it, claiming that our reservation was no longer, that we were disestablished. And of course, we have to go and walk the pavements in the halls of Congress and DC to kind of do an education process on that. And we asked the Department of Interior, please look at the history of the band. And also, just because the county decided that they wanted now to say disestablished reservation, and the county attorney at that time also said that any reference to the Mille Lacs Reservation and any of their correspondence, anything had to be removed. So nobody ever made the statement that there was a Mille Lacs Reservation. So I did a lot of work with the feds, and I tracked them down all over the country. Wherever they were, I was there, asking them what was going on with this determination about the reservation boundaries. And so it took me about 3 years, but in 2015, there was an M opinion, and that carries the weight of law, that stated that our reservation was never disestablished. And right after that, the Department of Justice approved our application for resumption of federal criminal jurisdiction on the reservation. So what happened at the county level in the Mille Lacs Band, soon as they heard about that, they revoked our joint powers agreement. And so they basically stated that our Mille Lacs Band officers could not enforce state law because there was no cooperative agreement. And if they decided to enforce law, then they would arrest those officers for violating law. So that's how crazy it got at the time. And so we're in the northern part of the county of Mille Lacs County. So we had a force of 32 officers. So they patrolled all of the northern part of the county. So then what happened when they said that they couldn't assume those responsibilities, that meant there was a whole area of Mille Lacs County that didn't have that law enforcement authority. And of course, our officers were very devastated. Morale declined and people left because they just couldn't come to work and have the fear of being arrested for doing their jobs. And so the county then decided, well, we'll hire a couple of people, additionals, but there was not enough of them, a couple that they hired to replace the 32 that we had in our law enforcement. And so the result of that, it got out in the system that Mille Lacs Band was a police-free zone. So guess what happened? We got a migration of the drug dealers from Chicago, from Detroit, from just anywhere they had heard. We even had a point where one of our band members' houses that are only allocated to a band member, we had drug dealers living in that house, and the band members had to leave and go somewhere else. And with all the rampant drug distribution, we started to really see an escalation of all the social ills. So people got addicted fairly quickly to the drugs, the levels. So when you look at that, that meant that some of these parents weren't able to take care of their children. So therefore, the children were pulled from homes, going into foster care. And we weren't prepared to see the number of children being removed from homes. So there weren't enough foster care homes on the reservation, so the kids went elsewhere. So that caused, and will continue to cause, trauma on those kids, probably for the rest of their lives. And of course, that was during the time of the opioid epidemic. And it was unbelievable the number of overdoses that we experienced on the reservation. And it was like 1 or 2 a week. And even today, that still hasn't stopped, because that impact of what had happened has really, has a long-term negative impact on people. And once you get addicted, how quickly you get addicted, it's time and years and commitment and all of these, dealing with the court systems that you have to work through, and that is very difficult for people. And of course, we talked to our governor, Dayton at the time, and his recommended solution is we go into mediation with the county, Mille Lacs County. So we did, and we were in mediation for about 6 months, and of course, there was no resolution whatsoever. And things got worse and got worse. And then I got a call from the federal government, from the Secretary of Interior, Zeke, and he had heard about this situation, so he said, I want to come to the reservation and see what's going on. And so he actually came, and he was able to see where all the drug houses were. We showed him all around different places. And so he directed the Bureau of Indian Affairs to assign law enforcement officers, additional ones to the reservation. And then also we got status for a lot of our officers as federal officers as well. And so we felt this was the straw that broke the camel's back. That the lack of respect from the county, all the devastation that we have to work now for generations to correct, that it was time for us to put our foot down, and so we did. And we filed lawsuit against the Mille Lacs County. Not only were we concerned about that negative involvement with their law enforcement, we also wanted to get the question of their determination that our reservation was disestablished. And so we went to federal court, they ruled in our favor, and it stated that our reservation had never been disestablished, and we all knew that. But it was an exercise from the county just to make sure that they gambled, hoping that something would happen for that, and it didn't work in their favor. And the problem with the current law enforcement agreement in the statute, 626.90, is that you have to have that cooperative agreement with the county. And we're a very negative kind of example of what happens when things don't work right. And so we are really concerned about that. And then, so we went back into mediation again in 2018, and we actually, it was election time as well, and so one of the candidates had talked about what they were gonna do about law enforcement in that area, and so that individual actually got elected. And so then we re-signed that JPA with the county of Mille Lacs. But unless something is done to correct that, we can face that again. So, and when we think about this whole issue, the Mille Lacs County has spent over $8 million in attorney's fees to try to fight the ban. And of course, that doesn't include our own legal fees as well. And so when you think about the county, Mille Lacs County, it's a poor county. We're the biggest job creator in the county. And many of the Mille Lacs County citizens, they work for the band because you have good benefits, you have education benefits, you have a steady job, you have college opportunity if you want to do that. And we're still in the legal system right now, trying to get all these resolved. Every time a decision is made, they appeal it. And so we go through that process again. And they even, Mille Lacs County wanted the state of Minnesota to pay for their legal fees because they were so high. And, but the state said no. And I know they were pretty devastated about that. And, but this is an example, I think, when there is a lack of respect for an Indian nation tribe in the state of Minnesota, where people want to have the upper hand, I guess, in a sense, and maybe history repeats itself over the years. And our position as a Mille Lacs band is that we want to provide good services in our area. And if you work for us, and we have our economic development properties, but we also have the tribal government where a lot of non-Indians come in, and we hire them because they have expertise that we need. And we have a big job ahead of us. But I know as we're moving forward and more people are educated and understand federal Indian law, which is very complex, and understand the Mille Lacs Band as a sovereign nation, what our goal is to, as we're moving forward, to provide for our memberships and to keep our people safe, and our community members too, if they are our members or not. We want to provide a good life for them as well and make sure they are safe. All of the people that come to visit us through our economic development areas like the casinos, that we want them to be safe when they come as well. And a long-term history and a very short-term perspective, but one of the many challenges that we face, and hopefully as we're going forward, we can get some of those resolved and we can move on to the next issue. Maybe educating our kids in the best possible way so they can be sitting in these rooms and help us make decisions that are good for the Mille Lacs Band and other citizens here in the state of Minnesota. Miigwech for listening.
Mado Chief Executive Benjamin, thank you for that. And I was asked here today to share Prairie Island's experience with this, and it directly picks up on the experience of the Mille Lacs Band. Because when Prairie Island learned of what was going on in Mille Lacs with the counties, it was very concerned that the same thing could happen at Prairie Island, where, as you heard from leadership today, we have a trifecta of really unprecedented threats. So normal, common legal issues are compounded by the risks that are experienced at Prairie Island. So the leaders in 2018 set out to address this statutory requirement for a mandate of a county agreement so that it didn't find itself with the inability to police its own jurisdiction, similar to what was happening up north. And just a little bit about the police department. 2003 is when it was established. It has over a dozen officers. All of them are Minnesota peace officers. They're all trained very well in emergency response. And the county agreement with Goodhue has been in place since 2003. I won't go over, I'll try to not repeat everything that was said both here by the chief executive and what you heard from the leadership today. But the relevant statutes, there's a couple different ones, and the one that covered Prairie Island was .93, has a number of provisions. But it does require that a cooperative agreement was entered into in order for the tribe to enforce state law. Now, I want to just stop there and make a little legal clarification that it's kind of funny, today we're here, it's Sovereignty Day, and what is one of the very basic tenets of sovereignty? And to me, it's being able to rule and make decisions and keep safe your jurisdiction. And the federal government, during a time where its goal was to get rid of tribes completely, one of the things it did was pass PL 280, which really took a lot of those tools. And other federal actions through court and statute have limited it so that we have very few tools to go after non-members who do bad things within our jurisdiction. And Public Law 280 was another example of that. So we really, when we talk about the tribes enforcing state law, it is a transfer of state jurisdiction to the tribes because that jurisdiction was taken away from us for us to be able to go after non-members. And we recognize that, but as you'll see, we believe that should be a state to tribe, a sovereign to sovereign transfer and relationship, and that the county should not hold the keys to our police officers being able to properly keep these jurisdictions safe. So this statute was created, as we heard, at a time where tribal policing was very young, but it did require, responsibility to be thoroughly accounted for through insurance, through being subject to liability, sovereign immunity waivers, state data practices laws apply, and they still do today. The cooperative agreement requirement in its time perhaps made sense because, again, these were developing functions. But currently, it's evolved to a different place. And there aren't requirements for what go in those agreements, so I think that in a lot of people's minds when they start to hear about this, they think that it means county oversight, and it does not. So right now for Prairie Island, our agreement does not have any sort of function where, if somebody gets stopped by the PIPD and there's an issue, they go to the county to resolve the complaint. That's not in the agreements today. Our chief Preem, who's not with us today, but he just talks about how community policing and how powerful that is within our jurisdiction, and I'll talk about that a little bit more later. But it's an interesting requirement, this is, because there's plenty of other jurisdictions, other police departments that don't have to have this. City police departments, Metro Transit, the state fair police, none of them have to have this type of agreement with the county in order to exercise their jurisdiction. It's only tribal police. So we set about to change a shall into a may, or a must into a may. And it was really interesting when we got here to start talking about this. There was resistance to even start looking at it. And it was, I think, the first thing that we got was it's just too complex. This is really complex, this is hard to understand, and that's absolutely true. It is. But we advocated and we sat in room after room with willing legislators. Well, maybe not all willing, but we took time to talk about this and to educate and to ask questions. And it is complex, but so is being friends with Phil Brodeen, and I still do. But if we really start to unpack this at the end, you'll understand that it is about, indeed, it's about relationships, which so many things are. So what the bill did was, what it didn't do is what I like to start with. It didn't change the jurisdiction of the county. It's still concurrent, as we heard about. That doesn't change at all. It doesn't give us any more. It doesn't give our officers any more ability to do anything other than they did and can do now. It doesn't reduce oversight. That remains with the post board. And it doesn't, this is another thing that we had a lot of questions about. Does this mean everything then goes to tribal court? No, it does not. It does not change the process for Prairie Island. Everything goes to the county. And the county attorney prosecutes everything. And, civil liberties, that was another question that we had. They all apply. This bill does nothing to change that. What it did do is it recognized our authority to exercise to protect the jurisdiction, whether that cooperative agreement was in place or not. So whether there was a political issue between the tribe and the county or some other reason, and some of those we've heard today. And it gives this community the knowledge that it can protect its members and its guests, and that is really important, and it's a really powerful piece of sovereignty. The things that we heard, the pushback that we heard, and I should have started with saying I have incredible respect for police officers, for law enforcement, and I have very, very strong positive feelings for the Prairie Island Police Department because of what I've seen them do in the community. But we heard a lot of fear, I shouldn't say mongering, but like the generation of a lot of fears, a lot of what ifs, a parade of possible horribles if we were to pass this bill. And we didn't feel that any of those were valid with respect to Prairie Island or with any of the tribal policing that we've seen. And, there are definitely stories of policing issues in this state and others, and we just had not seen the tribal policing issues be amongst those that that were valid and, credible. Tribal non-members who live within tribal jurisdictions, they are currently being policed by tribal police officers. So you have individuals who live in their lake homes or in their residential homes. They're still within a reservation, but so that doesn't change. They still are policed also by the county. So again, there's no difference there. We still have the sovereign immunity waivers. We still have the data privacy laws. We still have the ability for individuals to take up a complaint with the post board, with the county, through the county attorney processes are getting prosecuted. All of their defenses are there. There's nothing that changes or limits an individual's rights with this bill. And we talked about, well, when you go to Wisconsin, it's very similar. You have a jurisdiction that maybe you didn't elect the county sheriff, but you still have to be subject to their laws and their process. Through a lot of work and a lot of really willing partners, Senator Kunish, which you were in the House at the time, right? Was a champion for this bill. Jamie Becker-Finn was as well, and it passed resoundingly. Unfortunately, one thing that we did have to do was limit it to Prairie Island because at the time that was what we had to do to get the bill passed. But we felt that both for Prairie Island and for all the tribes, it was a step in the right direction. Oops. I passed through what's an important piece, so let me see. How do I get back there, Phil? Oh, here. There we go. So what's happened? What about all those scary scenarios that were forwarded? None of them have occurred. The county agreement is still in place. We still work very well with the county, with the cities, with other counties, in proximity, and we continue to develop those relationships because that's important to us. And Prairie Island, again, I wish Chief Preem was here because he could share. He's in several of these pictures. He's been there since the beginning, and the community knows the police officers, and the police officers know them, and it is a good thing. And now they know that they will be able to police and keep this community safe no matter what. You have now a bill that seeks to do that for the rest of the tribes in Minnesota that, Red Lake is an exception, I should mention, Bois Forte is an exception because of different jurisdictional dynamics there. But we have a bill that simply seeks to do the same for the rest of the tribes. And I believe that bill is coming up for some hearings, right? I would encourage the representatives and the senators in the room to just continue to ask questions of myself, of Tad, the professor, of anyone who you feel could help you understand this, and ask the hard questions. We absolutely want to walk through this with you as this bill moves forward. And for those that in Indian law are very familiar with the McGirt decision, it's a Supreme Court decision. It was about the jurisdiction and the reservation of my own tribe, but it was very powerful in its language about the states and the tribes and how we should proceed. And it talks about the fact that we can't tell the future. We can't tell what every single move is going to, what's going to unfold from that. But it's unclear why pessimism, why the negative should rule. And here, I've substituted out Oklahoma with Minnesota, but I do believe that Minnesota and the state have worked very well together and will continue to, and that this is a relationship that the focus should be between the state and the tribes themselves. And I'm gonna close with just an example of that. And it will make me, I'll try not to cry, but 2-3 years ago, we had a situation that I had to watch the video many times. And it was a man who was a tribal member. He's lived on the reservation all his life. And he was having a very bad day. He'd struggled in his life and, direct result of trauma and some of the things that we've talked about today. And he decided that he he took the police on a chase, and words were said that made it seem that he wanted to end his life that day by police. A long and very scary chase ensued with multiple jurisdictions, but leading that was a chief of police and other police who knew this man from when he was a child. And they knew him and his issues. And while it could have ended very, very differently, it didn't. And they took him in, and he lived to see another day. And, they called him by his name, the name that they knew of him as a little child, and they protected him, and they protected everyone else around. And so as you hear these stories about why this is a bad idea and why this could bring very bad outcomes, I want you to remember that example and the wonderful things that our tribal police are doing all over the Indian country. So, thank you.
All right, well, there's a question there, perfect.
Could you explain the Public 280 law?
Yes, since Phil is a much more brilliant lawyer than
Yes.
I, and he hasn't had a chance to talk, he can do that right now. And I thank you for that question, because I think we kind of skip over some of the big pieces of this, so thank you.
Yeah, so Public Law 280 from 1953 is a federal law that transfers criminal jurisdiction from the federal government to certain state governments. So right away, there were 5 federal law mandatory jurisdictions. Minnesota was one of them. So before the analysis in terms of criminal jurisdiction on Indian country, usually it went to the federal government under their General Crimes Act or Major Crimes Act. Now that got transferred to the states, and since 1953, states have had primary or concurrent criminal jurisdiction with tribes over Indian country. Since then, we have a line of cases that have further eroded tribal powers in terms of prosecuting cases. So one of the main ones is the Oliphant case, which said that Indian tribes don't have any criminal jurisdiction over non-Indians, which creates big problems. So I have a little bit of time, but I want 5 minutes for questions. So I'm going to tell 2 stories. The first is a case, US v. Cooley out of Montana. The Cooley case happened in the Crow Reservation. If you've ever been out there, beautiful, but very remote as well. A tribal police officer was out doing a patrol and saw somebody parked on the side of the road, went up and inquired, how are you doing? How are things going? It was the middle of the night. Soon became suspicious. And the person was, exhibiting some very odd actions, as well as, something just didn't feel right for the police officer out there. At the same time, the tribal police officer realized this was probably a non-member of the tribe, a non-Indian. So that, if you imagine a police officer out on the side of the road, in the middle of the night, it's windy, all kinds of things going on, and they're asking themselves, what can I do in this situation? So the police officer in Cooley went and apprehended the person and put them in his police car. Okay, that's pretty standard behavior for a police officer. The next step was doing a search incident to arrest of not only the person, but also the compartment, the car. Found drugs and found a loaded handgun in the car. Over 50 milligrams of methamphetamines, a bunch of money. Obviously something was afoot. That police officer's suspicions were proven correct. So the next thing that happened is there was a federal prosecution in Montana District Court. The district court ruled that since the police officer did not have a joint powers agreement or any authority coming from the state, they could not conduct a search incident to arrest. Therefore, all of the evidence that was from the drug trafficker that was obtained was fruit from the poisonous tree, and therefore excluded pursuant to the exclusionary rule. We litigated that, not we litigated that, but Indian country, anytime one Indian does something good, we take credit, everyone takes credit for it. So we litigated that, and that got to the Supreme Court in 2021. If you think, this sounds like a scenario that could have happened a long time ago, you'd think that cannot happen in present day times. There's more faith in tribal policing and things like that. No, this is a 2021 case. We found the Supreme Court unanimously decided that the tribal police officers could conduct a search incident to arrest and put the person in custody until another police officer showed up with the adequate jurisdiction to further process that person. But that's something we're still fighting about in 2021. And so while that's a win for Indian country, kind of, I guess, it still shows the stark need for bills such as the one that's currently pending that give tribal police officers the ability to do what they need to do and collect evidence and then submit it to a prosecutor that can then prosecute the crime.
Just like as an example, that's currently what happens in the Leech Lake area. So you think you've got these like Cass County Sheriff's deputies that are, Cass County's a really big county, and now you've got a Leech Lake cop has to sit and wait. So instead of that deputy doing their job elsewhere in the county, they gotta come get, so this is happening right now in Minnesota.
One final, so after that, I'll tell a story about probably my favorite person ever. My favorite person ever is my grandfather, Eugene Boje Sr. He was the chairperson of the Boys Fort Band in the 80s and signed the first gaming compact coming out of Boys Fort. I grew up next to him on the shores of Lake Vermilion. And one day we're sitting there and there was apparently a fire bug on the reservation that started my grandfather's car on fire, right? That thing burned, if you've never seen a car burn, that thing burned for 3 days. But here's in Boys Fort, we're non-public law 280, so we retroceded. The investigation on that was the funnest, not the funnest thing, but like one of the most depressing things to watch. So the tribal cops show up from the BIA and they just kind of go around the car and make sure it's not gonna start his house on fire. So that's the initial response. 2 weeks later, all of a sudden we see somebody over there kind of looking around the car and we're like, what is that? Here they're wearing blue windbreakers. They're the FBI. The FBI showed up to investigate the crime 2 weeks later on the Boys Fort Reservation. And their investigation consisted of walking around the car and kicking the tires a little bit and leaving. So that shows gaps in, while nobody was immediately in danger in that case, it still should have been given better, a better response than what we got from that. So that is another testament to the fact that we need tribal police officers and tribal law enforcement agencies with the adequate tools and capabilities to do what they need to do.
Senator Kunish.
Thank you. And, when we talk about the missing and murdered Indigenous relatives and that whole historic trauma, this is another example of how when somebody goes missing or has historically gone missing and it's reported, they have to wait for these different federal agencies to come and investigate. Well, if there's a deceased person and they have to wait for that investigator to come, how do you protect that crime scene? How do you protect that person so that a valid, untampered investigation can happen? And, as we've gone through this whole MMIR process, this is one of the biggest barriers to being able to address this issue in a very timely way. I mean, if it happens somewhere out in the woods up north and you have to wait for a BIA investigator to come, how do you protect that and preserve that crime scene in order to be able to gather information and any evidence? And so this is also a very big contributor to that whole problem around violence in Indian country.
Thank you. On that note, I apologize for getting here late. They called an audible on us at the last minute, so we're giving a presentation. But I have played a hand in putting this panel together, and I think it's a really good one. So if we could thank Chief Executive Melanie Benjamin, Jesse Syme, and Phil Brodeen. Chimigwech. So there's another breakout session in a few minutes.
We have a question?
Yes.
We have a question over here.
Oh, I'm sorry.
I'd like to make a comment. Looking at Boise Fort, that's a Red Lake Nation. We're a closed reservation, we're not a 280 tribe. So we have our own police department, we have our own courts, we have our own laws. So these non-members come and violate our laws. Our law enforcement stops us, put them in a police car, and we call Beltrami County to come pick them up at the line, okay? We confiscate their drugs, we confiscate their cash, and we keep it in a safe place. So Beltrami County picks them up. They release them next day. They said they don't have no case. But how can That'd be when we have an agreement with Beltrami County. See, we have a law enforcement agreement to work together, right? That's no agreement when they let them go the next day when we have the evidence. Then the FBI comes over, wants the evidence we confiscated, and they're not gonna be charged, because we did an illegal arrest because of Oliphant case. How are we gonna stop these drugs coming in when like the FBI or the law of Beltrami County Sheriff's Department do not cooperate with us? Because they classify our law enforcement not officers when they have all the schooling they went to the academy, they go to FBI training, but yet they're not classified as law enforcement. So what happened is, just put them in jail, put them in their cell, they're gonna let them go anywhere. Because what they do is when they let them go, they come back. And go same thing, we take them to the line, they pick them up and they let them go. So finally I got upset about it, just lock them up. We kept him about 3 months and they kept threatening me, I wouldn't, our law enforcement come up to, what are you gonna do, Chairman? You directed us to lock them up, just leave them locked. Because they're not doing their job, we're doing for them, we're saving lives, we're saving ODs. While they're incarcerated in our jail. So now they're gonna threaten me, they're gonna come and arrest me for obstruction of justice. So at the time, we had to make a deal. Our law enforcement made a deal that they'll let him go. So the FBI picked him up and they took him. And at the meantime, we had a removal order on him to stay off our reservation. Did that help? No. The FBI let him go, no charges. Same thing like the county does. So how the heck we're gonna cure our people from all these drugs that are coming in? Because all of our case gotta be fixed. We gotta start prosecuting these non-members in our own way, but because county and FBI, they let them go, well, we'll lock them up, save lives, or they're more worried about a non-member killing our people than our own members' safety. That reflects right to the trust responsibility that they're supposed to do, to save lives for our people, but they're not doing it.
So one of the things that the Mille Lacs Band of Ojibwe did when the Secretary of Interior, Zeke, came to the reservation and seen the devastation that we were experiencing, that they awarded us a salsa grant, it's called. And what that does is that we have an attorney that works with the U.S. Attorney's Office. So we were able to get those individuals that were on the reservation, we got them into federal court and successful. There was enough evidence and they ended up in federal prison. We had one guy that was showing up for like 20 years, same thing that you're experiencing, bringing in the drugs with him as well, but now he's in federal prison. I don't know if that really answers the question, but we're always looking for different tools that we can use to assist us in making sure that our community is safe. And we were fortunate that we had that opportunity. A lot of even our own elected officials don't understand that and the benefit of that, but it is a tool that we can use to help rid these individuals from our reservation when they bring so much devastation with them.
Yeah, our public safety director called me, he said, don't worry, Chairman, they're not gonna come and arrest you, we'll arrest them for trespassing.
There you
They come
go.
to the line.
Yeah.
That's what they told me, I said, okay.
I'll be very brief. Mike LaRock, I'm the Secretary Treasurer for the White Earth Nation. I'm a retired Director of Public Safety and Chief of Police of White Earth Nation. I guess we hear stories about how bad some of the agreements can go. In White Earth, in my tenure at White Earth, I can probably attest to how good it can probably go. Because with the three sheriffs that we have, Beltran, where we have Becker County, Clearwater County, and Monoman County. And as you know, that the White Earth Nation encompasses this whole Monoman County. And we've had very success with our agreements there with the counties, but they've always haven't been that way. With our Clearwater County, when I started working for White Earth Nation, they basically, Clearwater County would not get into a contractual agreement with us, which exposed our portion of Clearwater County on a White Earth reservation to be exposed to a lot of crime, what we're talking about and stuff like that. Because the county, and oftentimes doesn't have the personnel to actually cover 24/7. In Clearwater County, they only cover till 2 o'clock in the morning, then they're on call. So which opens the door for a lot of criminal activity. With White Earth Nation, we've also was the first tribe to, under TLOA, to get concurrent federal jurisdiction under TLOA. And we also looked at we had a salsa that was one of the county attorneys that took over that role as a salsa at one time. That in turn, she went on to be a district court judge, so she got out of that position. But it worked very well for us because a lot of the crimes the state crimes that were slipping through the cracks were getting caught by the federal system under the Major Crimes Act. And they were being prosecuted and stuff like that. So I just wanted to make a few comments about how some tribes, it's working well for, and then as we hear, other tribes, it doesn't work very well for. And with this bill that's going through, when we were gonna do the same thing that Prairie Island did, I met with the 3 county sheriffs because they told me I had to get recommendation letters from the 3 county sheriffs. And about 2 years ago, I went to them and I sat down with them and I explained everything to them, what we were trying to do. We wanted the agreements to be with the state, not the counties, because of the threats from the county sheriff saying, and the county commissioners saying that if you don't do this, we're gonna get out of the agreement, we're gonna take away your arrest powers. We're gonna do all that, and that's very detrimental to our reservations and stuff like that. So I got some kickback from all 3 sheriffs saying that they would not give me letters. This was 2 years ago. So hopefully this coming year and this coming session that we can get past that and get to where we need to go with this bill and give us our due, give us our tribal police our due. You know, it comes down to not only our due, but it comes down to funding and stuff like that. As you realize, most of our tribal police departments are funded by our general fund. Ours is totally, except for probably about 2% of the federal funding goes to our tribal police department, and our general fund, our casino, provides all of our funding for that. So, and I think for us doing as Public Law 280, we don't only police our own members, we police every non-member in our jurisdiction also. So that's part of the due that this bill, I think, actually needs to go forward to. I'll be testifying on Wednesday and Friday on this bill in the House and the Senate this week. So I just want to make a quick comment about that. Be good.
Thank you. And Madam Speaker, I'm doing the best I can to keep us on time.
We started late, Pat. We started late. So
I started late. Yes, ma'am.
Could I ask you a quick question, or does it need to be done? Oh. I was just wondering if you could comment on the deal with the counties and the DOC around probation to provide funding and authority over probation to the tribes. I'm really excited about it, and I'd just like to hear what your thoughts are and how you see that playing out. And that's my question.
Yeah, that's not something that I have been actively working on myself, Phil. I don't know if you have, but I am around it enough.
Can I answer that?
Yeah, please do. Please do.
I can answer that with the probation portion of it. We just got a pilot project, and Wendy Spry can talk a little bit about it. We have a pilot project with White Earth right now, where we have our tribal corrections, our assistant tribal correction officers, that we have a pilot project going on where our own tribal members are in these 2 positions, and they're the ones that help the Minnesota probation with helping get everybody. Wendy can explain it better than I can, so.
Do you want me to?
Yeah, go ahead, just if you could, Wendy, please.
All right, so right now we're working in partnership with the Department of Corrections and White Earth Nation. And they have hired 2 assistant probation officers who support all the work that the DOC agents are doing. So we have our higher risk people on supervision in this program. And so while the agents ourselves are meeting with people, we have the White Earth tribal staff, the probation staff, who are doing a lot more home visits. They're doing a lot more, how can we help you with housing, with employment, how can we support you spiritually, substance abuse, connection with local resources. And it's about almost a year old at this point, and it's growing, and there's a lot of good stuff happening with it. And so the legislation you're talking about is a proposal by the department, to hand over, allow the opportunity for tribes to take over supervision of their own tribal members within their own jurisdictions on each, tribal reservation. And included in that, of course, is that is funding, because we can give authority over, but if we can't fund it, so then there's a piece of it which is giving block grants to each, tribal nation to begin that process. And then there's more funding formulas that I don't know enough about, but I can ask you questions about supervision.
Okay, thanks.
Thank you, Wendy.
We have 2 minutes to get out of the room. If you're here for Indian Child Welfare Act, just stay where you're at. If you want to go to the Environment and Water presentation,
Yeah.
if you want to go to the Environment and Water, you go to room G3. And for Tribal Nation Gaming, you go to room G23. Is that close enough there?